Hi, thanks for joining us. This is Anthony Sonati, the founder of the National Association of Senior Advocates. Today, we're featuring elder law and estate planning attorneys. As you know, the goal of NAOSA is to educate consumers and give them the tools and information to make informed decisions whenever buying any product or service. Today, we're featuring 3 elder law attorneys throughout the country. And the goal of the call here is really just try to get some questions answered, questions that I have as a consumer that I hope you have as well. And again, get a bunch of common questions answered to the real professionals, the elder law attorneys. So today on the call, we have Jeff Hunt. Jeff hails out of Austin, Texas. We have Kimberly Hedgewood. Kimberly is out of Houston, Texas. And then we have Brandon Campbell. Brandon is out of Beverly, Massachusetts, a suburb of Boston. So first, could you guys introduce yourself? We'll start first with Jeff, if you don't mind.
Well, as Anthony said, I'm from Austin, Texas, and my practice covers a lot of area, but it's all confined to Central Texas area as far as geographically goes. And we have people come to us for a wide variety of problems, whether they are problems where the physical or mental health problems of an elder have recently come to surface, or the family or individual sees a need for long-term planning.
How long have you been doing elder law, Jeff?
I've been doing elder law for about 3 years.
Great. Well, thank you. And Kim, how about you?
My name is Kim Hegwood. I'm the managing partner and owner of Hegwood Law Group. We help families plan for the future, protect their loved ones, and guide them through the unexpected. We do a lot of planning for seniors. I laugh and tell people I've been doing this for 24 years and I miss my grandparents. So hanging out with other people's grandparents is just a joy. And so we really enjoy doing that sort of stuff. And we have lots of different practice areas, so we can basically take care of the family in just about most areas.
Great. Thank you. And Brandon.
I'm Brandon Campbell. I'm an estate planning and elder law attorney on the Massachusetts North Shore. I'm about 20 miles north of Boston on the coast. I've been a lawyer for about 20 years, but I really started focusing my practice on estate planning and elder law starting in 2015 because I had an incident with a close family member who fell ill, and it fell to me. At the time, I had a busy litigation practice, and this person's care fell to me, and it was at times overwhelming. And I decided that I wanted to change my practice and help people through these types of situations. You can find me on the web at northshoreplanning.com. I offer free 30-minute consultations in estate planning and elder law.
Great. Thank you. And we'll have links to everybody's website. Also, if anybody wants to search for an attorney in their area, just go to our professional finder, and you can find them right there as well. Jeff, I'm going to start with you. Could you tell me exactly what elder law is and estate planning? And when should someone come to you?
Elder law is an umbrella term that applies to all of the legal problems and opportunities that apply when a person is advancing in age. They should come to me as soon as possible.
Right. When should someone contact an elder law attorney, Kim?
Before you need one. And so I know that sounds kind of random. We want to see you. I usually start seeing clients on elder law issues after they turn 50. They're not necessarily ready for all that kind of stuff, but they usually start thinking about estate planning right then. And we always talk to them about long-term care planning, no matter what age they come in, because we've done Medicaid crisis planning for people as early as in their 30s. So things happen. So they usually start coming in around 50, updating old wills and things like that. And so then you start talking to them about, do you have a long-term care insurance? Do you have a long-term care plan? What does it look like? And then, kind of walk them through their different options, because when you come in early, you have options. When you wait, you don't have options. You have a crisis plan that's usually not pretty. Right. It works, but it's definitely not something the family's going to enjoy.
Brandon, when does a typical person see you, and when do you wish they would have seen you? I guess it is a good way to put it.
Well, a typical person, unfortunately, a lot of people wait too long to do their planning. Estate planning is really for almost all ages. I like to think of elder law as a specialized type of estate planning that deals more for older adults. And it, in addition to the usual issues, people are familiar with wills and trusts and that kind of thing. It also deals with issues of capacity and planning to preserve assets from the nursing home and planning to preserve hard-won assets from taxes.
Should someone call you if they're making minimum wage and no children and they're 30, or should they call you if they're making X with multiple children and multiple properties and assets and that type of thing?
Well, something that's common to all estate planning is planning for incapacity, and I think that that is important for everyone. Certainly, if you have any type of significant assets, then your estate planning becomes more important, but it is something that most people can benefit from. Even if you have a child who is turning 18, they may be going off to college. All of a sudden, you may want the parents to be granted access to their medical records, or be able to deal with their financial issues through a power of attorney. So you can start very early and even earlier if you have children with special needs.
Right.
But as people grow older and they retire and they start to have health problems and they start to worry about wanting to make sure that they don't become a burden on their family, that they don't run out of money before they die, they need to start thinking about seeing an elder law attorney.
Gotcha. Thank you. Thank you. So Jeff, let's go to you. What do you think the minimum planning should be done? Most consumers are afraid or anxious when they see an attorney because, cost and that type of thing. But what do you feel the minimum type of planning the average individual or couple should have at a very minimum?
In a large part depends on assets and circumstances, but planning for long-term care and planning for protecting assets from third parties, and to the extent that you're able to pass assets from generation to generation, planning to pass assets from generation to generation.
Right. Gotcha. So long-term care, can you explain that to me? What does that planning look like? Kim, I'll go to you on this one. So you say long-term care planning, long-term care insurance. Can you define what that? We all know what long-term care insurance is. What is long-term care planning exactly? What does that entail? And what's the purpose of it?
The purpose of planning for long-term care is the reality is that most people are going to become incapacitated before they pass away. So we're looking at lots, like Brandon talked about, we're always worried about incapacity issues. From there, you think about if you become incapacitated, you're going to be in the nursing home potentially. And so what do we do to protect the wife or husband at home, that spouse, whatever that spouse may be? So to make sure that they don't go broke while trying to get, pay for care for the loved one that's in the nursing home. So we look at it from an income and an asset, because that's how we have to do it, kind of an income and asset. What does your income look like where your assets are? Because it makes a difference where your assets are of how much I can protect right away, and then what I may have to do with what I couldn't protect right away. Mm-hmm. So we just kind of walk them through the process of this is what it looks like. If one of you ends up in the nursing home tomorrow, this kind of what it looks like. So if you do some better planning, so we do a lot of income only irrevocable trust to protect those non-retirement assets, investment accounts, savings, and things like that, to move them into trust and to start that 5-year look back period for Medicaid, which most states have. And so to give them the option of that spouse that doesn't end up in the nursing home, there's still the ability to have a good quality of life. And for me, it's all about planning for a good quality of life, because I think it's hugely important.
Yeah, coming from senior living, I mean, when people usually came in and spoke with me, usually one of the spouses has had an issue. It was a couple. Usually there's a medical issue that was the incentive to come in to check out senior living. And a lot of times it was too late. A lot of times the spouse had advanced dementia and they would not be accepted into the community, or financially they didn't have the assets to cover, the 10, 12, 14,000 a month to pay for that. So I've experienced that personally hundreds of times, actually, when people come in. So that's really important. Brandon, so how does someone protect themselves? I mean, that's a big deal. The country's getting older. The boomers are here. It's the largest population in the U.S. so far. We're having 10,000 a day turn 65 and older. A lot of people haven't saved enough for retirement. And then we have that big, long-term care thing happening. So what's the best way to protect oneself from that?
Well, there's generally three pathways, if you will. One of those is it's important to look to see if you can insure against long-term care costs. And there are long-term care policies. There are insurance policies with long-term care riders that provide benefits that if you get in while you're young enough and healthy enough, they may be a good option for you. Unfortunately, they're not affordable for many people, so it will depend on your circumstances. Another route is and I call this advanced planning, is protecting assets through either placing them into trust or employing gifting strategies so that you can get those assets essentially out of your estate, so they're not countable by Medicaid if you should have to go into a nursing home. The other track is the crisis planning. That's when somebody is either in the nursing home or they're on their way and they have to spend down their assets so that they can qualify for government benefits. That's usually not, those options are much more limited than if you get out in front of things and do the advanced planning. But there are things that you can even do at that latest stage. Gotcha.
So when a client comes in and sees you, you kind of look at the whole picture, then you ask for income, assets, children, and then you go from there as far as the planning. And the goal again is protect assets and the spouse from losing all their money just in case someone has a long-term care need, correct?
Yes, but I think it's more than that. I think it's more than just protecting assets. What I think what a good estate planning attorney or an elder law attorney really does is they take care of families. They take care of people when they get sick and when their spouse is trying to call the nursing home and can't get answers and doesn't know what to do and doesn't know how to pay the mortgage, or someone passes away and the children don't know what to do. That's what we really do as estate planning and elder law attorneys. It's not just about stuff and money. It's really about taking care of people.
Great.
That's how I look at it.
No, that's great. Thank you. Jeff, tell me what the difference between a will and a trust is.
Well, the way to look at it is that the will directs what is supposed to occur with your assets when you're dead. And a trust is a creation that holds assets that are placed into it.
Gotcha. So a will directs where assets are going after death. You said a trust is a tool where you place assets in to accomplish a certain goal, whatever that is. Is that right?
It holds assets.
Yeah. Okay. Does anybody want to expand on that? Kim or Brandon? Was that pretty simple? Pretty much what it is.
No, he's exactly right. A will is a testamentary document. It's for distributing assets to your beneficiaries after you pass away. A trust is much more broad than that. It's something that separates the control of an asset versus the right to enjoy that asset. And there are many reasons to do that. Protecting it from creditors, making sure that assets aren't squandered, sheltering assets from taxes.
So Kim, we'll go to you. Can you define elder law topics? When should planning be performed and updated? Certain life events, asset protection, and again, we talked about long-term care. So could you define that for us, please?
I think the timing depends on the family, and so depends on health issues, potential health issues. So you don't you ask the questions when someone comes in, do they have any health issues now? So you can kind of gauge of what's going to occur down the road. You have the issues of how often do you update? In my office, from 18 to about 70, we do it about every 3 years. After they turn 70, sorry, we want to do it about every 2 years. And when they hit their 80s and above, I like to see them every year. Because the older the power of attorneys are here in Texas, the harder they are to use. The other thing too is we look for elder law abuse because it's rampant. And unfortunately, families and caregivers are the biggest offenders. And so if I bring a client in and just have coffee and talk to them, maybe have them re-sign their power of attorneys because nothing has changed. I've learned a lot about what's going on in the past year and hopefully can avoid having problems, in the future, or definitely taking care of problems as they're occurring or as we can see them. Because we're all about protecting families. You don't become an elder law attorney without having a passion to protect seniors.
Right.
So, so for us, it's a lot of those kinds of levels.
Gotcha. Thank you. Brandon, what's a living will exactly, and why should everyone have one?
A living will is a document that explains what procedures you want to have taken as you're dying. Fun fact, Massachusetts, where I practice, is one of the, I think, maybe 2 states that does not recognize the validity of living wills. But I actually do them anyway because I find that they provide valuable information for the person you may have nominated to make healthcare decisions for you. But that's essentially what it is. It's you're checking out, and this is what you want to have done. It's especially important if you have any religious or philosophical wishes that you want taken with respect to your end of life care.
So is it a do not resuscitate, or is that basically what it is? A document
in Massachusetts, it is, there are DNRs, do not resuscitates. It is different in that in Massachusetts, only a medical provider can put those into place for a person. I would be interested to hear how it's different in other states.
Sure. Who wants to jump in?
And so I can. And so living wills in Texas are also called directive to physicians. They cover 2 circumstances. You're terminal, you're going to die in 6 months. How do you want that to be? Or you're incapacitated, you're never going to get any better. Do you want to be resuscitated if you have a heart attack or things like that? For me, it's a quality of life document. It's how do you want that end of life to occur? And we've gone back and added things to ours like, do you want CPR? Do you want a breathing machine? Do you want a feeding tube? Because that's a big one. A lot of times the nursing homes will tell families, if we don't put a feeding tube in, they're going to starve to death when you quit eating, but that's your body's natural way of going. So we put all those hard decisions in and let the clients decide how they want that to be. So it lessens what the medical power of attorney agents and the children have to decide.
Right. And the family members, again, in my experience, that's a huge burden on a family member. And I guess a living will, to me, is almost an obligation to your spouse and your children, just so you can relieve that burden from them. And is there anybody who should not have a living will who can, right? Is there any?
No, everyone should have them. I'll be honest though, we don't do them for the kids, early 18-year-olds, and
right, sure.
We do power of attorneys for 18 to 25-year-olds if we're doing the family's planning. And I don't normally do them then with them. And so, because I found that even with my own children doing them, they were a little freaked out about it. And so,
Right, sure.
and, so they're like, oh no, we're not dying. So don't even, they were just a little upset about it. So I just went, okay, we're not going to do that right now. As a parent in Texas, we can make those decisions for them in an emergency situation.
Right.
So, but, like in my family, their dad is the better person to make medical decisions than me, because he's way more level-headed in a crisis. And so I made them put him, him first. And so, yeah.
So, Brandon, let's ask you, what's a power of attorney, and who should be my power of attorney or anyone else's power of attorney? And why do I need it?
Great question. A power of attorney is a document that appoints somebody to make financial decisions on your behalf.
Mm-hmm.
And it is, in the context of older adults, it can be invaluable in the context of Medicaid planning. It should, I always tell people, with respect to a power of attorney, when you're selecting somebody as your attorney in fact, as they call it, the person who makes those financial decisions, if they have that document and they have bad intentions, they could rob you blind with it. So you have to pick a person that you trust 1,000%. And typically that's, if it's a spouse, trusted spouse is usually, or a child, but that decision is one of the most important ones that have to be made when employing that.
Is it for single people or is it for couples, or both?
It could be for anybody. I've had many older adults, widows who don't have a spouse, and they'll pick a very trusted friend or a relative, a niece or a nephew. But the important thing is to pick somebody who is mature, who is honest, and above all is trustworthy. And most people, and I have to ask people if they have doubts. I usually tell them this is probably not something that you should do, at least with that particular person. But it's a very important decision, and it must be carefully made.
And it's just for people who, you have a power of attorney. The purpose is if you can't make decisions on your own, that individual can then make them on your behalf, or can that individual, if I assign someone as a power of attorney, does that individual have immediate access to all of my funds, or how does that work exactly?
Depends on how the power of attorney is written. I generally write them very broad, but to give you a real life example, I had a call last week. A gentleman down in Florida, his brother lives up in Massachusetts. All of a sudden, he's in the nursing home. He's out of it. There's a mortgage that's due. There's money in an account, and there's no way to get to it. Short of having a power of attorney, you're left with going to court and getting a conservatorship. It's slow, it's expensive, it's unwieldy. It's not ideal in that type of situation.
Gotcha. Wow. This is a good example. All right. Well, thank you. All right, Jeff, what's a medical power of attorney?
Medical power of attorney is a limited power of attorney that applies only to the circumstances of making decisions about your health care and treatment when you are incapable of doing so yourself, and that incapacity is certified by your physician. So it's very limited, and yet it's very important because many people, or I guess all of us, are incapacitated when we go under anesthesia, and complications happen. And I recently went through this with a family member. Okay, who's going to be the power of attorney in case something happens? And it's happens all the time.
So a medical power of attorney designates an individual to make medical decisions on your behalf only if you're incapable of doing so, correct?
Correct.
Jeff, is that married with a living will as well? Is that the same thing, or is that two different things?
Living will applies only in the limited circumstance of end of life care, whereas the power of attorney applies basically for surgery.
Gotcha.
Surgery.
Okay. Understood. Okay, great. Well, thank you. This is really great, guys. Appreciate it. So we all know, and this is one of the reasons why we're part of the National Association of Senior Advocates, is consumer fraud. Fraud against older adults. And the majority of fraud committed by older adults is committed by family members, as Brandon, you said, and close friends. So what is the best way that an older adult, or really anybody, can protect themselves from a family member coming in and checking out $10,000? I'll give you a great story. I had someone call me a couple weeks ago. I'm seeing them tomorrow, where the mother made one of her children the power of attorney. She was diagnosed with dementia and couldn't really make decisions for herself, and the brother ended up just cleaning her out. Just completely cleaned her out, and they can't find him now. So, which is really sad, but unfortunately it happens all the time. You guys being in your business, I'm sure you hear it a lot, but is there a way that one can protect themselves from that happening? Anyone can take the call. I'll start with you, the question rather. I'll start with you, Kim. What's the best way to protect yourself? Let's say I do have a power of attorney, a POA, and I assigned it to a child of mine, but then things go awry. How does one protect themselves from that?
Sometimes, depending on where the assets are and things like that, it's very difficult to do. A lot depends on how much time ahead before you find out about it.
Yeah.
We find that law enforcement is not real good here to help people get it back when they've given somebody a power of attorney.
Yeah.
You can do some things like we do a lot of trust planning, and we use a lot of corporate trustees, so that there's, if something goes wrong with my money, they've got insurance. I'm not real worried about it. You have to pick those agents very carefully, and then you have to kind of monitor. And so as you start to decline, that's when you're going to find the abuse occurring. So depending on, who you pick, you may put some extra people in place. We've recommended that people talk to their financial advisors and say, hey, if anything goes out of the ordinary, here's who I need you to call. And maybe it's your alternate power of attorney agent or something. So there's only so much you can do. And then the rest of it, sometimes I think, is a hope and a prayer. Because if your family knows where everything is and they grab it and take off, it makes it very difficult, because usually by the time you find them, they don't have any money left.
Right.
So it's sometimes very difficult to get back. So we tell clients, when you're thinking about who you're putting in charge, you want somebody that's good with their money, no creditor issues, because if they're not good with your money, we don't want them with their money. We don't want them playing with yours. And so it's just a matter of how much safeguards can you put in place to kind of prevent that from happening, and really watching the stuff. So maybe if you're not watching it, have those statements sent to another child and say, hey, would you check on this every month, make sure everything's good in case I forget something.
Mm-hmm.
So I had a client come in and she's worried about making sure her bills get paid. And I said, well, set them up on automatic bill pay,
Right.
Or you can set that power of attorney to occur only upon incapacity, because you have that option. It's a little more difficult for us when we want to do, crisis plannings to get that doctor to put in writing you're incapacitated, because sometimes that's not real easy to do.
Just getting back to that. So a power of attorney does give the individual you delegate the authority to deduct money from your account right away, unless you put limitations on that. Is that correct?
It could, yes.
Okay.
A lot depends on the banks and things like that, because most
Right.
of your banks, depending on your big banks, they send the power of attorneys to legal. So you can't get anything for a week, maybe, by the time they
Right.
sit on it.
Yeah.
Because they have to be very careful, because they're liable if they take a bad one. So
Right.
they're always very cautious, but it's not that difficult to do, unfortunately, to get people to talk them out of their money. We see it happen a lot.
You think, Brandon, what do you think about a dual power of attorney, where two children, or a child and a close friend, or what do you think about that? I know there are some inconveniences, I guess, with that, but what's your opinion on that?
That can be a mechanism you can use so that one can put so there's like a check and balance kind of situation. If you put maybe you have two children, maybe you don't trust either one of them to make a decision, but
right.
You think that if they could come to unanimity, they might do the right thing. That might be a way to go. There is some added difficulty, as you intimated, when you have that, if you go to the bank, are they both going to have to go down to the bank together and sign and deal with every financial institution together on the phone? So it does add some hassle.
Give me a pro and con to that. Anybody can jump in. I mean, what's the pro of a single POA, power of attorney, and what's the pro of having two people jointly, two signatures before they can take money out of your bank account? Anybody can jump in. I'm just really curious about that. Jeff, you go ahead.
Yeah. When an estate is rather small, having two family members write checks is very workable. When an estate is larger, we find that it's very advantageous to make certain that there is a professional fiduciary who owes a fiduciary duty to be involved, and that is typically someone with a large trust company or a large law firm, where they're being employed specifically to exercise that fiduciary duty. Because it's one thing, for example, for one of my friends to ask me in an informal capacity, because they trust my judgment, to look over the shoulder of their kids when they're responsible for making decisions. It's another thing for them to hire my law firm and say, you're going to be responsible for making certain that the fiduciary, that you execute your fiduciary obligations to me.
Right.
And they're vastly different. Because having the deep pocket understands that their job is to prevent you from being fleeced, whether it's benign fleecing or intentional fleecing due to judgment problems. Benign fleecing, just that bad judgment. A professional fiduciary can actually step in and say, you know what, that's a bad decision. You're not buying an Escalade for your father who can't drive, right? Because you want to cat around in an Escalade.
Mm-hmm.
I mean, that's whereas if I'm talking to my nephew and he says, hey, I'm going to buy an Escalade for my dad, and I'm like, well, your father's probably never going to drive that Escalade. It's not a good idea. And my nephew can say, well, yeah, you're right, it's not a good idea, but I'm doing it anyway.
Right.
That's
great.
And they have to have the size and the insurance behind them to come after if they don't meet their fiduciary obligations.
Gotcha.
And that doesn't apply to smaller transactions. Smaller transactions, right, they just go away and the money goes away, and
right,
never any enforcement mechanism that's practical.
Gotcha.
You can have as many powers of attorney as you want. You could have 20 people be your power of attorney and they all have to work together, but that's the problem, right? You can get to a point where there's too many cooks in the kitchen.
Mm-hmm.
There's a famous case. It was a few years back with Casey Kasem. He named his wife. It was either power of attorney or healthcare proxy. And then he named his daughter from a previous marriage as the other agent, and it turned into a war, and they were fighting in court, and they were taking his body out of the nursing home in the middle of the night and moving him up, to different states. And it was, that can be the downside of naming a lot of different agents on your behalf. They might not all get along.
In spite of the fact that people kind of go, oh my God, I don't want to spend the money for, a corporate trustee or a professional fiduciary, sometimes that's the best thing to do, because that your money is protected. They have malpractice insurance. I mean, you don't worry as much. And most of them are very good at making money. So they're very good at maintaining your the amount of money you have, and then helping it grow, so that you don't see it as as this, oh my God, there's so much money coming out because, I've got to pay this, corporate fiduciary, or, that's, handling everything. So a lot just depends on, you really have to dig deep into family dynamics, and you got to spend time with families. You got to ask those hard questions that, that they don't want to, sometimes they don't want to answer. You tell them, I know you don't want to answer this because it seems so personal, but we have to know, because we can't help you come to a good decision without knowing everything about your family, the good, bad, the ugly, so because that's the only way we can help you and really truly do a good job for you, is by gathering all that information. And so when we do it, as extensive as we can, to make sure, and then, we encourage clients to go revisit that. That's why we want them to update them every 2 to 3 years. Our legislators in Texas just keep messing with them every 2 years. So that's always a problem. So we want them to current and up to date, but, you always want to make sure that, because circumstances change. Some kids are going along and they're fantastic children, and now all of a sudden they have a drug problem. We need to remove them, put somebody else on, so there's, you want to make sure that as things occur, your planning occurs with it. And so.
Gotcha. Thank you.
I've seen this happen it can be really ugly, but if you have the professionals involved, it really is a layer of security that you just don't get when you have only family members or friends involved.
So is that a institutional trustee, and they control your assets and they manage your assets, and they charge a % of assets type of thing, or is it a flat fee? How is that usually, or both, or one or the other? Both?
Depends.
Yeah, either both, one or the other. It just depends on the institution.
Gotcha. And when you're doing planning, you give people options, I'm assuming, and they understand the cost differences between going one way or the other. Correct? Yeah.
Yes.
Okay, great. Hey, thanks. All right, so let's see. Brandon, let's go back to you. Give me some really common planning mistakes that you see people come into your office with, and you wish you would have talked to them a year before, or 6 months, or what have you. Just give me some really common mistakes that you see the average family making that you wish you could talk to them prior.
Probably the most common mistake is not doing anything and waiting till there's a crisis and trying to be reactive where, proactive would have been much better. Unfortunately, there are a fair number of people who are willing to practice estate planning who shouldn't really be doing it because it's not their focus. Anybody who goes to law school and passes the bar can draft a will, but it's really an area that is complicated, and there are many pitfalls that just a sort of general practitioner is not going to see.
So what happens if I have an attorney write a will for me, and there's mistakes that you see in it? And I pass, will the state not accept that?
It depends on the mistake.
I got you.
So everything depends on the mistake. And
okay. Right.
There's a general reluctance among general practice attorneys to utilize trusts. You constantly hear financial planners and other professionals say they just need a will. They just need a will. Well, that's just absolute hogwash for individuals that have not $10 million of assets. I mean, a relatively small amount of assets, normal amount of assets.
Mm-hmm.
And I think the other thing is that failure to listen and to your attorneys when they tell someone that these are materially different outcomes. It's really hard to tell someone good legal advice that they just don't want to hear it because it's going to cost them money now. Right. Or it's going to cost them, they're going to have to make some decisions they just don't want to think about now. That's the thing that breaks my heart, is tell somebody this is going to have a very big effect in the future, and they just, well, you know what I mean.
Yeah, they don't want to hear it, head in the sand type of thing.
Right.
I get you.
So one of the things, Anthony, you ask about, things that we see, I think one of the big ones is in the power of attorneys, in the financial power of attorneys, because general estate planning attorneys draft kind of what I would call the bare minimum. And when you're practicing elder law, you need a very robust one. You need to have powerful gifting. I mean, you need to do a lot of things that most estate planning attorneys don't even think or know to put in their power of attorneys. And so you find people that have a power of attorney, but they can't do any gifting above the $15,000. And we may need them to gift hundreds of thousands of dollars, in order to protect assets, to qualify for Medicaid, whatever we need to do at that time. So not having an elder law attorney draft those power of attorneys really hurts a lot of families, because maybe we're now in guardianship court asking the court to allow us to do the things that a really well drafted power of attorney would have prevented. And it saves the families, thousands of dollars by having someone do it and do it well.
So you mentioned estate planning attorney versus elder law attorney. Is there a difference?
Yes.
Okay.
And so there's a lot of people, even just general practice attorneys, that do a lot of different things. Back when I started, because I've been doing this for 24 years now, feels like forever. I was more of a general practitioner. I did a little bit of probate, a little bit of guardianship, a little bit of family law kind of stuff. So mine were your typical, just the normal stuff that a normal estate planning attorney would do. But as you grow into an elder law practice and you educate yourselves, and I've done that a lot, really looking at making sure that we're doing all the best things that we can for clients. I know that what I did back then was, from an elder law perspective, was not enough.
Right.
So we reach back out to clients and go, it's time to update. Let's get them updated. Let's move them on to better planning. And so we tend to update power of attorneys a lot for people in my office.
So what's the question? Jeff, you want to jump in? Go ahead. I'm sorry.
Yeah. I want to touch on one of the things that she just mentioned, 24 years of experience. I have 3 years of experience.
Right.
I'm constantly telling clients, I don't know the answer to that. You need to speak with this type of attorney with this experience, because one of the functions that an attorney has when you're dealing with them is to tell you the limits of what they're competent to do. And that's the difference between being a good lawyer or solid lawyer and being an unethical lawyer. So I'm constantly telling people, I don't know the answer. You need a person with this expertise.
So what's the question I, as a consumer, can ask an attorney to make sure they are in fact qualified to do what I need them to do on all these topics we're talking about? Is there a certification? Is there something from the board, or is there something? What's that question or questions I should ask an attorney before I engage them to do my do my work?
I'm going to leave that to the senior attorney here and let her answer that.
Okay.
I want to know how much of it I've done, because I've, there's board certifications for estate planning and probate, but they don't really hit the elder law issues. There's the certification of elder law attorneys, a CELA, which is a good certification, for people to have, but nothing beats experience. And so from my perspective, because, I've had to update board certified attorney stuff to get it to do what we needed it to do.
Mm-hmm.
So how long you've been doing it, how often you do it, how much of your practice is elder law is huge for me. So I look at those types of things, because I tell most people, as lawyers, we can take a test. It doesn't make us good lawyers. So you want someone with lots of experience that has the ability. Yes, I've done this thousands and thousands of times, so
Right.
I know exactly what you need to do, because I do it all the time, every day, all day week, all day long, every week. So for me, experience counts for a lot. And so
there's experience, and there's also board certification. I'm sorry, Kim. So there's experience, there's board certification.
Certified elder law attorneys. And so that designation usually tells someone that they've had a lot of additional education.
Gotcha. Brandon, you want to jump in at all, or?
Yeah, CELAs are very good. You can look for a Master of Law degree in estate planning or taxation. But I would say that if you can get word of mouth, I mean, that's like anything. Word of mouth is really one of the best things that you can find. If you know somebody who's worked with them in the area that you're
Gotcha.
of your concern, and they've
Right.
had a good experience with them, then
Right.
that should go really far.
So everything we've talked about sounds really, really expensive, right? and that's what everybody's afraid of. Really, no, we're all afraid of walking into an attorney's office and getting hit with a specific bill. So could you talk about briefly money and tell me how affordable the minimum basic planning is? Is it affordable for your average family?
Depending on where you are in the country, depends on pricing.
Yeah.
And so and I'm not sure exactly the reason. It's a little more expensive on the East Coast to plan, because their nursing home bills are more expensive than what we have in Texas.
Mm-hmm.
I don't know why. And so they just seem to be that, planning can start as easy as, $750 all the way up to $15,000. It just depends on what you need and what you do. And so a lot of times it's just a matter of, you can come in and do something very simple, or you can do something very expensive. But if you're doing something of what you would consider expensive, you have to stop and think about, what are you getting in return?
Mm.
So if I spend $15,000 and I'm able to protect every bit of money that is out there, and the person gets to go into the nursing home's getting paid for, and the person at home doesn't lose anything, that's a huge value to them.
Mm-hmm.
And so, I really think it's a matter of really getting that point across. Yes, it may cost you a little bit more to get here, but look at what you're getting.
Yeah.
So, but I think it kind of ranges.
People are afraid of being overcharged. So, Jeff or Brandon, how do I know I'm dealing with an ethical attorney who's acting in my best interest? Besides being part of our organization, I think is a big deal. But besides that, say an attorney's not part of an organization, how does one know they're dealing with someone who's ethical?
Attorney fees are, as Kim said, they vary widely.
Yeah.
You're going to pay more if you go to a big city than if you're out in the suburbs. If you go to a big firm, you're going to generally pay a lot more than you would if you go to a small firm, but yet there are boutique firms that are very pricey. Really, what I think, if a good attorney is going to work within the person's budget and do the best that they can based on their financial situation. So, I will typically give people a range of options, and I tell them that I will work within your budget, and you are in the driver's seat. You can pick what it is that you want to do. And if you really can't, I wouldn't advise software, but if you really don't have anything to pay for an attorney, maybe that is better than nothing. But it is one of those things where you tend to get what you pay for.
Yes, I agree with Brandon a whole lot. I've seen some do-it-yourself stuff that cost the family way more for us to fix and to take care of their loved one than had they come in and done it and let us do it. And so initially, so
I mean, it sounds like a great strategy. Talking about do-it-yourself online software would be to talk to an elder law attorney first to see if you can afford it, right? And see if it can be done locally with a trusted attorney. If you can't afford it, I guess the online would be your option. But it doesn't sound like one should go to the online option just because they're going to save a ton of money. Is that pretty accurate?
I tell most people that if you mess it up, I'm going to make more money off your family fixing it and taking care of the problem than as if you had just paid me to do it. Most of us in the industry now, we take credit cards. You can pay as you go as long as you want, and that helps families a lot, having alternate payment, resources. And then too, sometimes it's maybe our job to point out where the money is so they can get it done, because they're not thinking about, oh, I could take it from this spot or this spot, so it just depends on how badly somebody, needs to do the planning.
I would strongly advise anyone against doing their planning themselves.
Right.
When you've run into some problems where people come to your office and they're woefully unprepared, it's a family tragedy. It creates massive conflicts. It cleaves families apart, and it enriches the tax man. And I don't see that there's any excuse myself. But then again, the attorney, because you did mention the attorney side of it, which is I'm the junior person here. If an attorney can't tell you whether or not they're qualified, then you need to find another attorney.
Gotcha.
An attorney, if they won't directly address that question, I mean, I'm highly qualified in some areas of law, and I'm less qualified in other areas of law.
Right.
And
got it.
Yeah.
Thanks, Jeff. Yeah, we're all passionate about older adults. I think we've all seen the tragedies of not planning or dealing with the wrong person, and it is heartbreaking, absolutely. And that's
unexpected,
part of the
unplanned
organization.
incapacity.
Pardon me?
Incapacity when there's been no incapacity planning. It's just terrible.
Yeah. So tell me, can you define what should be done on a flat fee basis? And a flat fee basis for everyone listening is where you need a simple will done, just as an example, and it's going to cost you $500 or whatever, and the attorney quotes you that flat fee. This is probably a hard question, I know, but where is the cutoff to where a flat fee doesn't make sense anymore?
I've seen a lot of attorneys that will just lowball you. You see the pricing, you think, how are they making any money? How are they paying their employees? So most attorneys, price their stuff, based on, somewhat industry standards, not too terribly. I see some that, may price theirs more. In my office, I tell people we're not the cheapest ones. We're not the most expensive. We're not the cheapest, but we do a lot of extra stuff that 99% of the other attorneys don't do. And so, and we walk them through what we do for that. Unless you have a very good will in place, when we do wills, we do entire will packages.
Right.
We do the wills, we do their power of attorneys, we do their directive, we do that HIPAA authorization. We do all those things that the client needs because we want to make sure at a minimum they have everything they need. And so it just kind of varies, I think, for the most part.
But how does one protect themselves from receiving a bill larger than what they thought it was going to be when they spoke?
It's in the contract.
Yeah.
Your contract, you should sign that contract. You should know what it says. And so our stuff says it's a flat fee. It also says that like we do a lot of trust planning in my office. So, and it says on our contract, if we have to do out-of-state deeds, it's an additional cost. And I tell clients about the range, about what it's going to be. And so
the contract's very specific. I'm just going to throw out examples. Just correct me if I'm wrong. So for a simple will, a power of attorney, a medical power of attorney, and 2 trusts, it's going to be X. And that's very specific. And that's how it should be written out, right, in the contract.
that's the way ours are. I've seen a lot of different things, but ours are very specific. The things that matter, I mean, we don't list every single thing that we do because we do a lot of little extra stuff. But the main things that you need are all, we lay them out kind of in a list, and you check the box, the little line next to it, so the client can very well see what it is that they're getting.
Yeah,
and
it's
Brennan,
very important to have the just to look at the fee agreement. If your attorney hands you a fee agreement with tiny little boilerplate that is 20 pages long and it looks like a commercial lease, you should probably run. It should be fairly upfront and clear, so that and it's good for the attorneys too, because I don't want to have any misunderstandings with my clients about money. I don't want them to think that I'm in any way taking advantage of them. So that's abhorrent to me. So I want them to understand. It benefits me. It makes them understand. At the same time, there are certain things that we do that are hard to estimate. I don't charge flat fees for probate, because probate is a court proceeding and it can go very smoothly, or all the relatives can start fighting over the property and it turns into World War III. So it's there's just no guarantees. But I'd say that for most elder law planning and estate planning, most attorneys are going to offer flat fees. And as Kim said, you just make sure they follow the agreement.
So if you don't understand the agreement, don't sign it. That sounds obvious, but I mean, being in any office of a professional financial planner, attorney, you name it, you're intimidated. They put the document in front of you and you're intimidated. So that's a really great advice. If you don't understand it, don't sign it. It should be very clear. It shouldn't be 20 pages. I guess you can't tell me how many pages it should be, but it should be simple and very easy to understand. Is that fair?
Yeah. Our trust contracts are probably the longer of our contracts. In really, the first few pages tells you everything we are doing, and the rest of it says everything we're not doing. Gotcha. And so there's no misunderstanding about what it covers, because we want to be very clear with clients. We want them to know this is what you're doing. And so, and Brandon, something I found that's helped us in our practice, because we do a lot of flat fee probate and guardianship work, but we've adjusted that paragraph that says, here's your fee, as long as there's no additional problems. It's a flat fee unless you go over that amount, and then it kicks into hourly. And that helps, so a client has a pretty clear idea, because I've been doing this a long time. I know exactly how much it takes to get something done.
Yeah, it's the nature of law that people, they're not expert in the law, and they have to rely upon us to tell them the scope of services that they might want to take advantage of or might need, and to educate them enough to make informed decisions. All of that is on us. That's the importance of informing them of what we're not doing.
What if someone calls you, Jeff, and they engage you to do 4 or 5 things, and they call you and say, "Oh, hey, Jeff, what do you think about this?" I mean, that happens a lot to attorneys, which is not fair, because it's taking your time.
Well, the first thing is for me to be willing to tell them, frankly, look, we didn't discuss that in our previous 5 discussions. This is a new subject, and I could discuss it with you for 5 or 10 minutes here, but the reality is you're asking me to do 4 hours of legal work. So let's talk about this, and whether you need it or not, and whether it's going to be beneficial to you and what the risks are. And then let's make an informed decision. Does that make sense? Because you need the permission and the buy-in of the client to help them at this point. And it could very well be that they're asking you a question that you should have answered in that initial other 5 meetings. And if their question or their request evidences that they were not properly informed or they were making a decision based on faulty understanding, it's on you,
Right?
the attorney. It's very important for the attorney to be very frank in their own assessment of how they're doing their job. I mean, we owe these clients a fiduciary duty, and I take that duty very seriously, which is why that's why I'm an attorney.
Right. No, right. Is there any reason someone should be surprised by the bill they receive for the planning? Is there any reason that you can think of?
Sure.
Anybody?
Yes.
You can't think of one? Okay.
I can think of one, which is that poor communications between the parties, between the attorney and the client. And in that situation, the question comes up pretty naturally is, was the client listening to the attorney? Was the attorney frank and properly engaged in it, in his or her explanation of
Gotcha. Okay.
the costs?
If the agreement says it's going to cost X amount, I should not be surprised if it's over that. Right.
Well, if it says X amount for a shoe shine,
Right.
and I'm going to do a lawyer's shoe shine for you, and then it turns out that you didn't know that a lawyer's shoe shine meant I'm only going to shine a pair of flip-flops and not your military boots, that's the lawyer's fault. We didn't
That's
tell
right.
you what kind of shine we're giving you. So
Gotcha.
a lot of this is in the lawyer's control. I mean, at least in my experience is that miscommunication, especially when you have a client who's not highly sophisticated, when you have a client who's high net worth and not highly sophisticated, that can be a very troublesome engagement because they are relying on you to an extraordinary extent, right?
Yeah.
And they didn't necessarily have come into those resources by sophistication.
Gotcha.
That makes sense.
Yeah, it does. I understand. Right. Does anybody else want to add to that?
Yeah, at least in Massachusetts, if as an attorney, I want to bill somebody for something that is past what was in the fee agreement, I need to get the client's permission first. So there should be something in writing, some communication from the attorney saying, look, things happen, things can zigzag and go a different route. And then all of a sudden, there's more work that's required, but the attorney should be upfront about it. This is what needs to be done. This is what it costs. Do I have your authorization? And you should be looking for that in writing.
Gotcha. And that's part of our gold standards of professional practice as well. So good. Excellent. Kim, do you want to add to that or?
No, I agree wholeheartedly.
Yeah.
And so we lay our stuff out as simple as we can and to make it just as easy for a client to see. And then, if there's additional work that needs to get done, Brandon and Jeff are right. We have to do that in writing because I think we have an obligation to the client to do just that.
So everyone, I want to thank you once again for being part of this conversation. It was fantastic. And this is just an example of the great professionals that are part of the National Association of Senior Advocates. We are here to help. We're here to educate you as a consumer and make sure that you have the best people in front of you at all times to give you the best advice, no matter what it is you're looking for. And these are just great examples. There's some fantastic attorneys in Texas and Massachusetts. And if you ever need any help, feel free to give them a call or just check out any of our other professionals via our website. So thank you again, guys. I really appreciate it. And we'll talk again soon.